You're not observant, it will be difficult for you. I'll give a case which was guided by me. It was doctor's family, so I helped them where MTP has happened. Lekuna was being MTP. Wife's signature was not there on a consent. Learned advocate presented to the court that even husband's signature is suffice. Lots of argument done when this patient came to me. Sorry, doctor came to me. I said, in all given scenario situation, your MCI Act, just observe, because it was observation. The signature verification, observation that there is a signature which authentically needed to. And then MCI Act very clearly says that both the partners' signature is required, which has been narrated under also. Helped him to win the case. Orthopedic surgeon whose brother died in hospital, 2 months of admission, was keen observer, being a doctor. In first 7-8 days, bleeding, as per the doctor, team was stopped, but still blood transfusion was needed, hemoglobin was going down. He himself, being a doctor, suggested to do HRCT because he found in one of the X-rays suddenly seen by his RMO and then confirmed by him that there is a refraction. It was ignored by various radiologists and doctors. Found to have a 6 ribs fracture leading to bleeding of the patient. And then he became more concerned in all medical paper. And where at one stage, vancomycin injection was prescribed by the team of doctor, 2 grams 3 times a day for 6 days or 7 days. When patient died, he has taken ground of that because being a doctor, he was knowing that maximum doses of vancomycin is 2 grams a day. An overdose of vancomycin, literature shows that causing nephrotoxicity, neurotoxicity, where cause of death is multi-organ failure. He could be able to detect all that. Observe. Become a good medico-legal consultant, you need to be observant. Whenever you read a medical report in front of you, be observant. You'll find lots of lacunas which need to be covered up or need to pull to argue the matter. Not only that, but even in the case of even in any cases, once. So be observant. And if you're observant, you will find lots of things to argue the matter. Second important aspect as a secret to win any cases in the court of law is to have a command on precedents. Because our law is like that. Our law says that precedent created by upper court is mandated to be followed by lower. The issue is same. If Supreme Court has given some judgment, National Commission has given some judgment, State Commission has given some judgment. All these judgments are binding, having a binding effect on forum. If you got such a good judgment, you all can definitely utilize the same for arguing the matter in a court of law. Believe me, my friend, because of the law of this land, this law of the land, if you can prove that such a judgment has already been on the same ratio, the lower judge, no matter that judgment is right or wrong in eyes of his, have to follow. That's the reason why judgment plays a vital role in law practice. And you'll go, if you read all the cases of the country, you can read any Supreme Court judge, or say any Supreme Court judge, or a National Commission judge, in their judgment, lots of case laws may have been cited while giving an order. Multiple case laws have been cited by both the parties. And every judges have to interpret the citations in view of the ratio presented by the consuls. And if you can able to do that, you learn the tactic of using. Believe me, my friend, you will never ever lose any case. That is what is the secret of the law. With all blessings, I have not lost any case. But I use these tactics. If there's a case of a consent, go with Manchanda case. Manchanda case has categorically defined the law of consent. Read which paragraph is going to be more effective. Read where your client's ratio is matching with the judgment. When I talk about criminal case against the doctor, go to Jacob-Matthew case. So beautifully narrated every aspect of criminal medical negligence in Jacob-Matthew, still holding good. I'm talking about 2005 judgment. After years, still holding good. If any criminal case is filed against the doctor, your client, use this judgment. Judgment, every paragraph speaks loudly. Very clearly says that medical science is a complex science. Complexity the same is beyond imagination of medical practice. Hence, medical accident in the form of death. Doctor must not be responsible for criminal liability. But if you read whole judgment, it always and everywhere talked about due. If due care has been given, then your client can be safeguarded. Safeguard your, because I'll tell you 99% cases which are going to come to you on a phone call are going to be death-related cases. Because my doctor gets feared when that happens. And they get feared only because they feel there is going to be police action against them. Help them with this judgment. Tell them nothing is going to worry, not to worry, nothing is going to happen. Because this judgment, same judgment further says, to fasten criminal liability, the negligence must be gross. The word used, gross. All simple medical negligence can go to consumer. To define the gross, again, this court has taken lots of effort. Judgment. If you read the same judgment, my friend, they have narrated case of Gupta to just clarify, and this was also decided by Supreme Court. Citation was of Gupta, where in DNA surgery, IT tube of smaller size was put by the doctor. Patient aspirated and died. Question came that proper size of tube was not being used. Honorable Supreme Court said it can not set a gross medical. It also comes under the simple medical. So there's no question of criminal lab. In Jacob-Matthew case, where oxygen cylinder put on a patient, respiratory distress, got emptied. Another cylinder was in second room when doctors brought it, taken a time to get open because of knob was which is right. In that bargain of 2, 3, 5 minutes, patient died. The Honorable Supreme Court said this also does not come under the gross. So you can take advantage of every single case of death comes to you. You look to the parameter of gross and if it is simple, criminal liability is not going to be there. In crude word, in a simple word, if I want to define a gross, I always say gross means which can be seen by the eyes, like cross-pathy practice. Injection given by cross-pathy practice, no, which is not allowed as per the law of their state, leading to septicemia and death, can definitely be a gross. On the basis of same, the Poonam Verma's case of 1995, after almost 35 years later, 25 years, I'm sorry, around 26 years later also, that judgment holds good. In Poonam Verma's case, there's again a landmark judgment. Court has observed the doctor has given all proper treatment to the patient. Absolutely all care has been given by the doctor, including the investigation, including the medication, including the transfer of the patient, including the handling of the patient to the particular doctor for further treatment. There's no question that doctor is negligent of his duty, but the law is law. And what they have observed, that Homeopathic Act, the CCH Act is supreme, we all know. The CCH Act at one section very clearly mentioned the doctor registered under CCH can practice homeopathy only. Because of this only word, the word of only, the judgment has gone against the doctor and then become a law of the land. Today, the Poonam Verma case, believe me, my friend, after 25 years, 26 years, still been cited in multiple cases of cross-pathy in the country. And then law executor, I got no option to follow this ratio. Today also, if case goes, consumer 4 are related to cross-pathy practice. In spite of every possible care taken by the doctor, been proven by the doctor, only because of this judgment, scenario get changed because ratio of that judgment been cited in every judgment. Similarly, in the case of Tanaka Nizamuddin Hospital of Hyderabad, the cross speciality law got defined. I have touched on cross-pathy. Now I'm touching on cross speciality, where this patient got admitted for fever. During investigation, they found mass in thoracic region. It was reported to thoracic surgeon because thoracic region is of thoracic surgeon. Thoracic surgeon has posted a patient for surgery. When they have opened the cage and started dissecting, they found it is fibroneuroma, which was extended up to spinal cord. That bargain, they've injured the spinal cord, patient on paraplegia, remained for 6 months, got discharged on wheelchair, filed a case, matter gone up to Honorable Supreme Court. The question in front of a Supreme Court was that being a neuro field, why thoracic surgeon has operated the case. And counsel has cited the MCI Act, an amendment which has amended the schedule of various surgeons and protected every specialty under the Act. As I said, in Poonam Verma case, CCH Act was cited. In this case, MCI Act was cited, where scheduled of specialty has been defined. In this case, they have argued only on the matter that when neurosurgeon was available, being a corporate hospital, if they would have called neurosurgeon, preferably at that particular moment, the result would have been different. Honorable Supreme Court has found the same and found doctor as a guilt. They said when neurosurgeon was available, at least for the standby, he should have been called. And on that ground, the judgment has gone against the doctor and been cited in various cases in this country where gynecologist has given anesthesia, where surgeon has given anesthesia, something has gone wrong in various fields. And that is the only place where latest development of the country of a cosmetic domain has been changed in a various way, where there's no cosmetic surgeon category, where no hair transplant case surgery or surgeon. Lots of cases are being cited in the court of. If you go and see one of the beautiful judgment given by Honorable Supreme Court in Kusum Kumar's case, a very clear guidelines has been defined by Honorable Supreme Court to decide any medical negligence cases. And that guidelines become a mandate for the lower court and the lower consumer forum to follow. If that guidelines my doctor fits, then chances of winning the cases are high. Go and read that judgment. It's a beautiful judgment. Beautiful guidelines given. If you see that guidelines, we all doctor. We see all doctor are following this while doing the practice. These are the judgments, not only this, but multiple judgments. And it's not stopped. Very recently, the judgment came of Honorable Supreme Court, which says only for death, doctor cannot be responsible. Go and read such a good judgment. One judgment which has again clarified all the doubts of medical policies of hospital and individual doctor. Because in this case, what happened, the hospital was not having a policy where in cataract surgery, if a patient died, doctor were having a policy, indemnity policy. But doctor was not made a party. Hospital was made a party. Hospital has taken a plea that doctor was already indemnified, so insurance company should pay and treating doctor. It has all happened because of treating doctor. It was in favor of insurance company, but when Mentor got to Supreme Court category, National Commission category defined that error omission policy of hospital is different, professional indemnity policy of doctor is different. If hospital was not having a policy, it is a duty of hospital to pay the compensation, not the insurance company. This become the judgment for the future. Very recent judgment, if you all remember, which is challenged in Supreme Court, but yet no result came, was on written consent, which was being decided in R.G. Stone's case by National Commission, where they said written consent with a few blank space with the place of signing of a patient and witness is unfair trade practice. The opportunity to the patient is not been given. It is high-headedness of the hospital. The consent is improper. And on the basis of that, they said it is unfair trade practice and 10 lakh penalty to be deposited in legal aid as another judgment which can be cited in near future for all written consent. These are the judgment and continuously judgments are coming. It's not the judgment stop. Continuously judgments are coming every day, every time. New things get decided. Believe me, my friend, if you really can help yourself by reading all this, contact us. We are there to help you. Can really make a difference in eyes of your client. I have just given an example of few, but there's a multi. So another secret of winning the case is using precedent in your practice. And third, and very important secret of winning the case or creating impression is listening. I know you're expert, but yet my humble request, whenever any client comes to you, please give enough time to him to explain his agony and ask a leading question to get more clarity. Because more information you collect, more your mind is going to work and more you are going to be efficient in handling the case. With part information, you may be good putting your mind, but I can say lots of things can be missed if not been properly. Another important factor, I'll tell you, it is important for you to understand how to handle the cases, how to read the papers, how to look to the things, how you can really contact your people and guide them. So every factors, by and large, impact your practice. My humble request that being a medical legal consultant, future medical legal consultant, be cool, put your ideas in action, put your knowledge in action, and start generating a good business, become a good